I want to welcome you to our 11th annual Free State Foundation Telecom Policy Conference. When I say the 11th, I have to pinch myself. I remember back when I was saying the second, third, and so forth. So I'm excited about this conference, and I'm excited to have all of you here. Each year, I say in so many words, more or less, that our conference just keeps getting bigger, better, and more impactful. And I say I'm going to keep saying it as long as it remains true. So consider it said. The theme of this year's conference is Internet Providers and Platforms Getting Law and Policy Right. To be sure, many of the issues that we will discuss this year have been addressed at previous conferences. For example, net neutrality. You knew what I was going to say, right? It's been debated in one form or another for the last 11 conferences. But let us pray. We can pray together that one day soon I might not be saying the same thing. But other issues such as privacy and data security are at the forefront this year in a way that they previously have not been. More generally, issues relating to the proper framework for considering the respective roles in the Internet ecosystem of Internet service providers like Verizon and Comcast and so-called platform providers like Google and Facebook are, after the FCC's Restoring Internet Freedom order, certainly front and center. At the Free State Foundation, we assert, without apology, that faithfulness to free market policies, along with respect for property rights and the rule of law, are guiding first principles. But we know that not everyone shares our philosophical disposition, and even among those who do, there certainly may be differences regarding practical application of the principles in particular cases. That's the getting law and policy right that's part of this year's theme. While I'm sure net neutrality, privacy regulation, and 5G will be the subject of considerable discussion today, rest assured there will also be plenty of debate regarding today's other hot topics, such as furthering broadband infrastructure development, whether wireline or wireless, closing remaining digital divides, and continuing FCC institutional reform, all in the context, again, of getting law and policy right. Now, as you know, Assistant Attorney General Makan, Delrahim, head of the DOJ's Antitrust Division, was scheduled to give the opening keynote address, but late yesterday afternoon, a personal matter arose that prevents Mr. Delrahim from being with us this morning. Fortunately, Andrew Finch, the Principal Assistant Deputy Attorney General, is with us today to deliver the remarks that Makan would have delivered. He'll be followed this morning by NTIA Administrator David Reddle, and the traditional lunchtime conversation will feature 4 members of the Free State Foundation's prestigious Board of Academic Advisors, Tim Brennan, Michelle Connolly, Daniel Lyons, and Christopher Yu. The session immediately after lunch features FCC Commissioner Michael O'Reilly in a conversation moderated by Tom Talkey. And then FTC Chairman Joe Simons will give the closing keynote. And we have 2 panel sessions this morning featuring senior officials, all well-known experts. Our goal is to educate, stimulate discussion, and through civil discourse, perhaps even move a few steps closer to reaching consensus. In any event, because there's no charge to attend, and because our lunch will be even more sumptuous than that breakfast over there, I can't offer a money-back guarantee. I'll just express my confidence that the conference will be informative, interesting, and even at times, perhaps even entertaining. As always, I'll remain grateful for your interest and participation in the Free State Foundation's programs and activities, and for your personal friendship. Now, I just want to mention before I bring up Andrew 2 things. You've got our Twitter handle on the brochures, hashtag FSFCONF11. Okay, so please feel free to tweet away. The other thing I want to mention, I might even do it later during the conference too, but I'm just going to mention 3 of our most recent books. They're all available on Amazon along with the earlier titles, but the most recent one is a reader on net neutrality and restoring internet freedom. That's a collection of a whole bunch of essays, principally by our academic board members. I don't think it's going to be out of date, despite my best wishes, anytime soon. So this is a useful collection. When we eventually update the Communications Act, which I hope to see one day, we have this book, hashtag ComAct Update. Remember when we started that update process 4 or 5 years ago in the House Commerce Committee? That's a useful collection of work. And then finally, as many of you know, we also work in the intellectual property area, and our book, The Constitutional Foundations of Intellectual Property, from a natural rights perspective, you might find interesting for those of you interested in intellectual property. So with that, I'm pleased to introduce Andrew Finch. Again, Andrew is the Principal Deputy Assistant Attorney General. Did I get that right? See, I didn't have much time to really practice that because as I said, I just found out last night. But I'm very pleased that Andrew is here to fill in for Makan. Thank you.
Thanks for that introduction, Randy. Thanks for welcoming me to step in for Makan. He was very much looking forward to being here to kick off the conference today, and he very sincerely regrets not being able to be here in person to deliver these remarks. We at the Antitrust Division very much admire the Free States Foundation's commitment to eliminating unnecessary and unproductive regulatory mandates. We also share its goal of promoting a deep understanding of the benefits of free market competition. Like the Free State Foundation, we at the Antitrust Division spend considerable time promoting the use of rigorous economic analysis to understand the proper role of government in the economy. Our goal as law enforcers is to police the rules of the road for businesses in order to ensure that competition works and that it delivers on the promise of Adam Smith's invisible hand. In light of those shared principles and the theme of today's conference, Randy invited us to talk about the internet ecosystem and specifically how antitrust law informs the recent debate about whether and how to regulate digital platforms that operate in a vertical relationship with internet service providers. With so much public attention focused these days on the potential for anti-competitive conduct in digital markets, a common refrain is that digital platform companies are too big and they're doing too much. This is, in many ways, a concern about vertical integration. To understand the arguments for and against vertical integration, it's important to think about the distinct markets across which companies in the internet ecosystem sometimes vertically integrate. People do a disservice to this important debate when they lump together all sorts of companies and activities under one big umbrella, calling for investigations into big tech or big data. As any good antitrust lawyer can tell you, it's important to define the markets that you investigate and to understand where the competitive constraints in that market are coming from. It's not persuasive simply to argue that Facebook, Amazon, Apple, Netflix, or Google, the so-called FANG companies, are big and powerful and that everything they do is therefore anti-competitive. We need more economic rigor than that. It's also not persuasive every time parties come in and tell us that they have to merge or they have to do something because one or more of the FANG companies is competing with them or will soon be their competitor. And we hear that quite a bit. There is, in fact, some confusion over this in our antitrust case against the merger of AT&T and Time Warner. AT&T, through its ownership of DirecTV, is the largest pay TV provider in the U.S., and when it bought Time Warner, it sought to vertically integrate upstream into content production and distribution. The division challenged the acquisition because we believe the merged entity would have the incentive and ability to use Time Warner's content as a weapon in its negotiation against rival pay TV companies. Some critics argued that this sort of vertical integration shouldn't cause any concern at all because other companies in the industry, like Netflix, Amazon, and Hulu, were, they argued, also vertically integrated between content production and content delivery. Although the rise of Netflix and Amazon is, no doubt, an important competitive trend in the production of content, there's an important distinction to be made here, and one that careful observers of the internet ecosystem will recognize. Netflix and other content distributors that use the internet to reach customers aren't vertically integrated in the same way that a pay TV company is. Pay TV companies control the pipes, or in this case, the satellite dishes that bring content into a consumer's house. Netflix, on the other hand, depends on internet service providers to reach the consumer. As a result, these over-the-top providers may not competitively constrain pay TV companies' behavior in the same way they would if they were fully vertically integrated downstream all the way into the consumer's home. Another relevant distinction between internet service providers and the platforms or content distributors that sit on top of them is that they may face different barriers to entry at distinct levels of the markets in which they compete. Building a broadband or mobile network requires an enormous capital investment, and economies of scale might make concentration in the market efficient. The barriers to entry for digital platforms, on the other hand, might be low in some cases. Some commentators have challenged this idea by suggesting that platforms benefit from network effects, and that is, the more users the service has, the more valuable it is to those users. Platforms that serve two sides of a market, such as users on the one side and advertisers on the other, also benefit from indirect network effects. The more users a service has, the more valuable it is to advertisers and vice versa. These network effects, like economies of scale, suggest that concentration sometimes might be efficient and that entry might be difficult as a result. The division's case against Microsoft many years ago actually featured this important aspect of platform competition. The court found that Microsoft had a 95% market share in the relevant market, which was Intel-compatible PC operating systems, and that Microsoft's position in the market was protected by a substantial entry barrier, which the court referred to as the applications entry barrier. Although the court didn't use the phrase indirect network effects, what it called the applications barrier to entry was essentially that. The court observed that most consumers prefer operating systems for which a large number of applications have already been written, and most developers prefer to write for operating systems that already have a substantial consumer base. That was almost 20 years ago in 2001. Interestingly, a recent Harvard Business Review article observed that the strength of network effects can vary dramatically and can change over time. While network effects often lead to competition for the market rather than in the market, they don't necessarily create a durable market power or high barriers to entry. The Harvard Business Review article explains, for example, how, in the video game industry, companies have alternated taking the lead over the years, depending on who has the newest technological advantage in the hit games. Though game developers prefer to develop games for popular consoles, as a general matter, consumers may be willing to switch consoles on the strength of just one attractive game. As a result, a game console's leadership in the market may not be particularly durable. And one factor in consumers' willingness to switch is the price of the console. Indeed, the underlying research shows that game consoles typically match each other's prices. Of course, online platforms are typically free for consumers, making switching even more likely. Vulnerability to multi-homing is another constraint on digital platforms, and that in turn creates the opportunity for entry. Multi-homing is when users use more than one platform for the same purpose. Again, all else equal, multi-homing occurs more often when the cost of adopting an additional platform is low. Take Uber and Lyft, for example. It's essentially costless for a user to download the Uber and Lyft applications on a phone, and passengers can easily switch between services depending on which one is cheaper, as long as there are enough drivers on the other side of the platform. Overall, then, barriers to entry may be higher for internet service providers than they are for some of the platforms that sit on top of the internet service providers. One upshot of this is that vertical integration between the platform's content creation function and the internet service provider function may be especially risky to competition. Vertical integration can, in general, threaten competition by raising barriers to entry. For instance, when successive monopolists in a supply chain each control the inputs necessary for anyone to enter and provide competition at the other level of the market, then their vertical integration is likely to require any potential rival to build both capacities at once in order to enter and to compete at either level of the market. The difficulty of entering the internet service provider level of the market may amplify this problem. If an entrepreneur spots room for improvement at the content level, but it can't reach consumers without building its own high-speed internet networks at extremely high cost, then competition at the content creation level of the market may suffer. Even setting aside barriers to entry and focusing on digital platforms that sit on top of the internet service providers, there are risks from vertical integration. These risks raise concern among those people who believe that Google and Amazon may do too much, because each of them aggregate products as a platform service, but also sell some of the products on the platform. One of the risks here is that vertically integrated companies might be able to raise downstream rivals' costs when they have access to a scarce input that everyone downstream needs. An important thing to keep in mind for this theory of harm is that scarcity is a key component of the analysis. For example, in AT&T and Time Warner, we were concerned that the vertical integration might cause harm because Time Warner's content is scarce and valuable to pay TV providers downstream. In contrast, we did not challenge the vertical aspects of the merger between CVS and Aetna because there are much closer substitutes in the market for CVS's pharmacy benefit management and retail pharmacy services and for Aetna's health insurance business. CVS and Aetna just don't have the same leverage over their rivals they would have if they controlled truly scarce inputs. With respect to digital markets, a common refrain is that vertically integrated platforms have access to data that potential rivals need to compete. As in all cases, our analysis must focus on the facts and whether that data is a scarce and valuable input into the supply chain. Sometimes data is neither scarce nor valuable. But if the data plays an important role in designing the products or services for the consumer, and it's available only to a platform service because, for instance, the data is created by the user's interaction with that service, then there might be an ability to raise rivals' costs downstream. Importantly, when we think about the potential for a vertically integrated company to harm its rivals or gain a competitive advantage, we as antitrust enforcers must keep in mind that there is a different standard for cases involving anti-competitive acquisitions under Section 7 of the Clayton Act than there is for the standard under Sections 1 and 2 of the Sherman Act. As the D.C. Circuit opinion in AT&T was very clear, and I actually think this is a significant win, an important development for our jurisprudence, the court applied Section 7 to that vertical merger in the same way it has to horizontal mergers. It said Section 7 applies a much more stringent standard than does the rule of reason analysis under Section 1 of the Sherman Act. And there are important reasons for that approach. While Sections 1 and 2 of the Sherman Act are inherently backward-looking, Section 7 looks to the future. It asks whether the effect of an acquisition may be substantially lessen competition and tend to create a monopoly. If the answer is yes, then the merger is illegal. The Section 7 standard allows the division to act before a problem arises. Its purpose is to keep the structure of the market competitive so that market forces can play out to the benefit of consumers without the day-to-day policing of whether players in the market are behaving anti-competitively. For this reason, merger review requires the division to address circumstances that wouldn't necessarily be illegal under Section 1 or 2 of the Sherman Act. For example, under Section 7, a merger to monopoly would be illegal. But outside the merger context, the Antitrust Division doesn't seek to break up a monopoly that has been lawfully acquired and maintained and that is not engaging in exclusionary or predatory conduct. We should also be careful when it comes to breaking up monopolies that are the product of innovation or organic growth, particularly the kinds that result from making a better or cheaper mousetrap for consumers. Penalizing such monopolies could likely harm investment and economic growth because it would penalize success. The Supreme Court expressly recognized this in Trinco when Justice Scalia wrote that the mere possession of monopoly power and the concomitant charging of monopoly prices is not only not unlawful, but it's an important element of the free market system. We try to remember this principle when thinking about the digital economy. Too often, discussions focus on what measures would rein in the power or advantages that successful tech platforms have obtained now in the present. But we should pause to think about the time in the past when the innovation and investment were driven by the goal of obtaining those advantages that would be available to the company that succeeded and was the best and fastest at meeting the needs of consumers. That sort of race is the very thing that the antitrust laws are designed to encourage. So while it may seem like we're stuck in the present, and so that we shouldn't worry now about whatever the conditions were in the past that created the success for the FANG companies and others, history has proven that disruptive innovation can topple giants. That's why we must carefully ensure that we maintain the conditions that encourage innovation. We should not overregulate. We should not force a company to share the source of its competitive advantage if it won them and maintains them through competition on the merits. The next generation of innovators might very well surprise us if we maintain those incentives that encourage them to do exactly that. All of that being said, some sources of competitive advantage in the digital economy may indeed be ripe for abuse. If the only purpose of refusing to share data or code or other technology inputs is to handicap a rival, that may be an antitrust violation. One way to tell whether such a tactic might be anti-competitive could be to look at a company's approach to interoperability or data portability. If the company makes an exception to a general preference for openness in order to block rivals or potential rivals, that might indicate that the business strategy is problematic. These issues require careful consideration. The world is watching, and entrepreneurs are deciding where and how to invest their time and energy. We at the Antitrust Division are committed to policing the rules of the road for businesses in order to ensure that competition works, and that includes recognizing the benefits of vertical integration and maintaining the incentives to innovate. Competition will be all the more vigorous as a result of our efforts. Thanks for your attention today. Keep up the good work at today's conference and in the future, because these are important issues that are continuing to unfold. Thank you.
We're going to do a couple questions.
Okay.
Andrew, thank you very much for that. You can tell Makan that I don't think he could have delivered his remarks any better than you did. So thanks. And I apologize to Andrew. I didn't have a chance to even pull down his bio last night, except I did glance at it, so he didn't print it up. But so I'm going to ask this first question, and then we're going to take a couple of questions if you have any. But I noticed on his bio there was a line that said "fun fact," okay? And the fun fact was I believe, if I recall this correctly, that Andrew and Makan, Delrahim, and one other person, I forget who it was, had the same dog as a pet, and it was a dog that I have never heard of in my life. Not being a dog person. So the first question, and then we're going to get to some that might even be more important than this. Tell us just about that dog, and then we'll have a couple more questions.
It's a very special dog. It's a Coton de Tulare, which is the royal dog of Madagascar. Wonderful little white, fluffy, sometimes yappy dog. I have one, Barry Nigro, who's a dag with me. He's got pictures and a breeder. He'd be happy to send you to. Coincidentally, Barry and I both got to the division and realized we both had these fabulous dogs, and Macon went out and got one. So that made it into the fun facts for last year's ABA spring meeting brochure, and there are going to be more fun facts this year. Okay.
Was I the only one that didn't know anything about that dog? I don't know. Okay. Well, with that said, do we have any questions? And you can pretend they're for Macon, or you can actually
either way
say they're for Andrew. Do we have any? No questions at all? Okay, well, I see one. And if you could identify yourself by name and where you're from, that would be good.
Good morning. Brooks Harlow, Lucas LaFuria, practice telecommunications law. I don't really have a question per se, although feel free to comment on what you think went wrong in the AT&T case. But I can just tell you, having fought Bell for 30 years and the vertical integration, including at least one industry that was under a price squeeze that we documented with their own cost studies, it's a serious problem. And I don't know why you couldn't convince Judge Leon. Maybe you want to answer what went wrong there, because the issue's really there.
Well, I won't comment more broadly on the topic of what went wrong, although we are, at the Antitrust Division, are thinking hard about what kinds of improvements we could make, what we would have done differently naturally. As I've said before publicly, I think you learn 10 times more from the cases you lose than you do from the ones you win. I think an interesting thing that makes the case very fact-specific and was a particular challenge was the post-complaint arbitration offer that was made by Turner. It said if the merger goes through, we will agree to arbitrate and not black out rival distributors during the period of the arbitration. And that was an interesting, successful, I think, litigation strategy on behalf of the merging parties, and was an interesting development. And one thing that we're thinking about at the Antitrust Division is what that means for future cases, because it shouldn't be the case that parties think that they can just come in with a fix right at the end or after a complaint is filed and change the playing field. So we're going to try to work on ways to address that and prepare for that in the future. But that's one thing that we would do differently.
Okay. Do we have any other questions? Gentleman in the back.
Thank you. My name is Drew Clark with BroadbandBreakfast.com. Very interesting presentation. Could you just emphasize, I think it'd be of value for the people here and elsewhere, if you could just emphasize those things that are important to underscore, because you come in an interesting position, having challenged the AT&T Time Warner merger, and now you seem to suggest a lot of people are coming to you and say, hey, there's all these other problems with vertical mergers, and you're saying, no, as long as there's no illegal actions in the obtaining of the monopoly, you don't want to punish success. Could you just, as succinctly as you could, restate those tests that are vital in order to overcome the hurdles and get to the point where you think there are challengeable claims?
Well, if you're talking about sort of monopoly, putting vertical integration to the side, I mean, what I was talking about in terms of monopoly is that, the monopolies, if they are maintained through exclusionary or predatory conduct raise concerns. I think what you're getting at maybe when I said that we don't challenge monopolies in and of themselves if they were, lawfully obtained through competition on the merits and continue to be maintained through competition on the merits. If they're maintained through exclusionary or predatory conduct, then we have an issue. With regard to vertical mergers, I guess what you may be thinking about was a sort of implicit in my comments was that, yeah, very few, we've said this before, very few vertical mergers will necessarily raise issues. I mean, many of them have efficiencies that may come with them through the elimination of double marginalization and other types of efficiencies. And so, that it's not the case that vertical mergers are always or nearly always problematic. Certainly not.
Okay, well, I don't want to burden Andrew. If there's one other question, we'll take one more, and then that will have to be it. This gentleman up front. Just wait for the mic 1 second.
Sir, my name is Tamar Chatterjee, Safe Foundation. Sir, you mentioned during your speech the Cvs Aetna merger, and I have a question on that. Now, I don't know whether this is a vertical or a parallel merger. Whatever it is, one would have assumed that a cozy relationship between insurance and the healthcare provider / pharmacy should raise some red flags, but since it didn't and it was approved, my question is, why are the stocks, CVS stocks, going down? So can you, whatever data you have, can you throw some light on it?
Well, unfortunately, no, I can't. I mean, I don't know anything about what's happening with their stocks or why. I mean, we looked at the merger both with respect to potential vertical issues and horizontal issues as we ordinarily do. Did see a horizontal issue and sought a divestiture of one of the businesses, and that's still under review by the district court here in Washington, D.C. But beyond that, I really can't comment on the stock price or what the effect of the merger may be on the stock price.
Okay, well, with a question that's a little outside of our realm, I think that's a good place. That's the first time we've had one on that subject, so thank you. I want you in just a moment to join me in thanking Andrew. But Andrew, if we have a tradition here of just giving, the expression, a small token of thanks, and for our keynote speakers, and we make sure it's usually very small, also cheap, usually, because we want to try to fit in any guidelines that are appropriate. So I've got this bag, Free State Foundation. It might have been used, which might make it even cheaper, but hopefully you can take it and use it. If not, give it to someone who can. And join me in thanking Andrew.